Okay, so here we are once again at the Global Class Actions Symposium 2025, and Clare Ducksbury of Epiq is with me. Not always of Epiq, formerly Case Pilot, so it's been a very busy year.
It has.
So before we talk about the symposium, how are you settling in with your new overlords?
Settling in very well at Epiq, yes. They have proven to be a very good home for Case Pilots. We're very pleased to have joined them and looking forward to all the vision we have and ambition we have together.
What has joining forces with Epiq done for the organisation here in the UK?
Well, I think what it's done is really bolster the breadth of experience and expertise. So, as many of your viewers will know, Epiq were a very established claims administrator in the US. They've done a significant amount of settlements, some of the biggest settlements in the US, in Australia, in Canada, and they therefore had a lot of sort of historical experience that they could bring to us in the UK. And then Case Pilots was set up from the beginning and has always been very focused on delivering services in collective redress matters in the UK and Europe. So it's a real marrying of the ways, really, and they bring a huge amount of scale and experience while we bring a vast amount of local knowledge.
We've heard a lot already this morning, and we will do over the next couple of days, of how everybody's attitudes to this evolving sector of the law is changing, from the claimants to the defendants to the funders to the lawyers. But focusing on the claimants, have you noticed as the system in the UK gets more mature and people are more aware of a class actions regime, whether their expectations have evolved, and in what way?
They have, yeah. I'm pleased you touched on awareness, because that's one of the challenges, actually. Not insurmountable, but it is a challenge. Yeah. But yeah, I think expectations have changed, and those expectations are very much in line with cultural habits and how people are living their lives differently. You know, we're incredibly digitally enabled these days as culturally. Our citizens expect to be able to jump on their smartphones and manage all of their business, their professional life, their personal life, and they expect everything to be very imminent and very happen now. So it's our job to make sure we deliver services that resonate with all of those requirements. So, by making sure that everything we do is mobile friendly, by pushing notifications to claimants to let them know that there's action they need to take, by looking on their behalf for data that might already be out there that can help support their claim, to take the burden away from them of actually finding that information. And then, of course, we have the payments piece on the end, and this is the challenge, and this goes directly towards take-up rates and participation rates, and that's a hot topic of conversation, and it's something that the Competition Appeal Tribunal are quite rightly very interested in. There is a reluctance to provide bank details, and I completely appreciate that reluctance, and it's right, that reluctance should be there. So it's our job as administrators, and what we're doing is to look at other ways to deliver redress that don't necessarily mean you have to hand over bank details. So credits to your PayPal account, all that needs is an email address. Issuing a prepaid debit or credit card, again, that can be done with an email address. So it's about understanding how our audience are living their lives, and we, in a lot of the classes that we're a claims administrator on, it's not just individuals, it's businesses as well. So understanding how they their habits and how they are living their lives, and making sure that we deliver services that resonate with that.
Sure. And before I let you go and have a well-earned coffee, because you've just admitted not to having had your breakfast yet. What do you feel the value of events like this? In fact, not like this. This
particular one.
Yeah.
I think they're hugely valuable, and the fact that the room is so well attended and that we've got such a diverse sort of portfolio of attendees is demonstrative of that, because there is so much to talk about, and I'm pleased there's so much to talk about. Maybe 5 years ago when we were attending these events, and probably you and I were speaking then, there was less to talk about. but there is so much to talk about now. It's such a fast-moving area of legal practice in the UK. You know, it's not just about the opt-out class actions, but the opt-in environment, as Megan was saying this morning. There's lots happening there as well. And of course, you know, we've got the introduction of the RAD, the Representatives Action Directive, which is now being implemented across all of Europe. And we can see all of these European jurisdictions that are adopting opt-out mechanisms into their domestic law in varying ways, in different ways. So unless we have events like this, and events that are culturally diverse and really looking at these kind of cases at a global level, we don't have the necessary sort of sharing of information that will help all of these regimes develop.
Claire, fantastic. You've given me gold. Thank you so much. Go and have a coffee and a bun.
I will
enjoy.
do. A bun as well. Thank you.
Absolutely. It's on the house. See you next year.
Thank you, Rob. Thank you very much.
Cheers.